The theme of the special session is Quarter of C Charter, moderated by Mr. Andrew Mudok, Legal Director, Foreign and Commonwealth Office of the United Kingdom. The distinguished panelists of this panel include Professor Rüdiger Wolfrum, former President of the International Tribunal for the Law of the Sea, Professor Helmut Tuerk, former Vice President of the Tribunal for International Law of the Sea, Ms. Thanh, Vice Secretary General, Vietnam Society of International Law. And the discussion of this panel is Professor Beckman, Director of the Center of International Law, the National University of Singapore. So may I invite all the distinguished panelists, discussion and moderator of this panel, please come to the stage so that we can have this session.
Well, thank you very much to the organisers for bringing this very distinguished panel together. I don't include myself in that list, but some very distinguished speakers that I'm very much looking forward to hearing from. You've all got the bios of all the speakers. I'm not going to use our time to reiterate those, and we've also just heard the names of all the panelists. So I'm going to use the time as productively as possible. After quick short remarks, we'll hear from each of the three speakers before Professor Beckman does his role as a discussant. Then I'll hopefully engage in a few questions of the panel before hopefully leaving time for some Q&A with the audience. So I would encourage all the speakers to try and keep to their allotted time as much as possible to allow time for the discussions. So we've heard from the video montages and our keynote speaker, the negotiations of the convention between 73 and 82 led to an incredibly impressive multilateral treaty. And it really is, particularly perhaps in today's times, a real high point in multilateralism. It had many key unique features within the treaty, which I will not reiterate. But this panel now is going to look constructively at some of those achievements and perhaps challenge a little bit on what could happen next. So we'll look at the rise of the convention, we'll assess its efficiency, and then I think we'll then turn to looking and exploring whether it's still fit for purpose and what areas would be useful to engage in any further development. So without further ado, over to my first speaker, Professor Wolfrum.
Thank you very much, Chairman, for your introduction. A minute ago, I still saw the clock ticking, but it has been closed. I believe we should really pay tribute to the Law of the Sea Conference, the third UN conference on the law of the sea, to be exact, and to the work of the institutions under the convention. As my colleague and friend Stanislaw Pawlak has indicated, he actually makes my task much easier for my presentation. The Law of the Sea Tribunal is one of the institutions which is meant to develop further upon the Law of the Sea Convention. The convention is actually, and has been referred to as such, kind of, you refer to it as a charter, I would rather refer to it as a kind of a constitution. And it should be interpreted as such. The term constitution doesn't come from me, it comes from Tomiko, actually. I will deal with the convention from three aspects. When you look upon 25 years, no, 30 years of being in force, you look backward and you look forward. And I believe that the Law of the Sea Convention has passed the test. It has been successful in the past, and it depends on all of us implementing the convention whether in future it will also be successful. I will try to explain three areas where this is particularly necessary, although I would just say these are not the only three areas, but these are ones which are in everybody's minds. Most of them, they have to deal with environmental matters. When the Law of the Sea Convention was concluded in 1982, the international environmental law was actually not yet in existence. We had the 1972 Stockholm Declaration, but the real international environmental law came about only in 1992 with the Rio Declaration. That means 10 years later. Therefore, it has been argued frequently, more than once, that it is necessary to renegotiate the convention to include the modern environmental law. I believe this would be a mistake, even a bad mistake. The Law of the Sea Convention, as I said, is kind of a constitution, and therefore it contains very often not the exact rules, but divides the competences in this respect, identifying the entities which should provide certain rules. Apart from that, and this is my first point, it is whether a progressive interpretation could help us in this respect. Let me first to be very concrete. The idea of a precautionary principle has not been developed when the Law of the Sea Convention was adopted. This term didn't exist, even less the term sustainable development. Now, what did the Law of the Sea Tribunal do? In the southern bluefin tuna cases, New Zealand and Australia versus Japan, the ITLOS has decided that the precautionary principle, or in this case, it was referred to as approach, was applicable. And the order issued by the ITLOS took this into account. It could do so by another interpretation. In the convention, we have a regime on fisheries, and in part 12, we have a regime on the protection of the environment. But in this order, the tribunal stated that fisheries is also part and parcel of the environmental concept, and therefore applied under article concerning the environment, which is quite comprehensive. This is, however, not the only innovation that the Law of the Sea Tribunal brought about. As Judge Pawlak has already referred to, the advisory opinion initiated by West African states, I shouldn't go into details, but here the Law of the Sea Tribunal made use of the principle of sustainable development. Again, this regime has not been developed in 1982 or until 1982. It came up much later in the modern form and was brought about first in the fisheries regulations, strategic stocks, etc., and is now very dominantly focusing in the draft regulation on the exploitation of mineral resources. What does the term or the regime sustainable development means? It does not mean only environment. And that is a huge step between Stockholm and Rio. Rio came to the conclusion that the protection of the environment is achieved best not by putting the environment into a refrigerator and preserve it, but putting limits to the use of the environment. And by doing so, we come up now under sustainable development with a regime which protects the resources by careful management, by listening to scientific advice, and using the precautionary principle, but still continuing using the resources which are referred to. The best example for the sustainable development system is you may find in the Biodiversity Convention. I have understood the message. I should put the micro closer to my mouth. I will do so. And this is being referred to in practice in the advisory opinion on the West African, issued by the West African states. Let me now come to another issue. I have referred to it indirectly and I will repeat it. The central provision of the Convention on the protection of the environment is, you find in Article 192. This provision is already referred to in the Southern Bluefin Tuna case, but it should be applied and recognized more frequently. What does it mean? This provision puts an obligation on every state, my emphasis is on every state, for the protection of the environment. It has a different meaning for the coastal state. For the coastal state, it means an obligation to protect the environment. However, it's balanced by Article 193, according to which states may use their resources according to their national law, taking into account international law. 192, however, obliges every other state to protect the environment. And in the already mentioned advisory opinion, it was said very clearly that those ships fishing in the exclusive economic zones of West Africa, in brackets, they were mostly European fishing vessels, should enforce and enforce also the national rules of the coastal state concerned. This goes quite far. We had a case in Germany a couple of years ago, decided upon by a court in Hamburg, not the Law Sea Tribunal, this was internal, which declared the pollution of a port in Scotland by a German vessel as being in violation of Article 192, and therefore by the provisions under German law. This is a very far-reaching interpretation, but I fully endorse it. Let me move to my second element, but concluding the first one. What we are doing is in ITLOS what I would qualify as a progressive interpretation of the existing rules, and this is easy, in particular since many of the rules are open-ended and are designed so to be filled with new developed international law. Let me come to my second concern, which is much more complicated to solve. If you look into the regime on the exclusive economic zone as well as the continental shelf, you will find in Article 56 an obligation of states to protect the environment, again, in this case, against pollution from seabed activities undertaken under coastal state jurisdiction. Sounds good enough. It is not. The problem is there is a reference to international rules, standards, and practices. We have none. There is no international organization which can produce such rules, standards, and practices for the economic use of the continental shelf and the exclusive economic zone. This is different from navigation. Here we have IMO with MARPOL and everything else. And we have means which do that even for the Arctic. But we don't do this for the continental shelf. The situation gets worse. This Article 56 only applies to the EEZ, not to the continental shelf. Now you can argue it doesn't make any difference. The competence is the same. But what's about the outer continental shelf? There we have no 56 and no equivalent. I would argue that still one should apply 56, but I must confess it's legally not that easy. Here, I consider this a significant risk for the environment. If you compare the rules of Norway concerning oil rigs with the ones of the United States, you see significant differences. Have you ever heard of an accident with an oil rig under the Norwegian jurisdiction? You have not. Therefore, it is very important that either globally or regionally, a conference is being concluded to solve this gap. It is not necessary to have a new convention or an international agreement. It could be done like port state control in a memorandum of understanding. Let me come to a further element in this context. Soon, deep seabed mining will be a reality, and the rules for the protection of the environment are very, very significant as drafted by the International Seabed Authority. What about the same activities on the outer continental shelf done by coastal states? They are not bound by these rules issued by the International Seabed Authority. The International Seabed Authority has legislative powers, but only in respect to the area. How do we solve the problem that not one state has an inferior standard on, let's say, manganese nodules, polymetallic nodules, on the outer continental shelf compared to the one in the deep seabed? There's no system for harmonization. My advice in this context is a little bit drastic. The International Seabed Authority should issue and has a competence to do so, to exclude every industry doing inferior standard exploitation of mineral resources on the outer continental shelf compared to the standards applied in this area. Can be easily done for in choosing an applicant. You can and have to take into account in the International Seabed Authority past performances. Therefore, this is the entrance door for such a possibility. My third question is, or my third issue, which is considered as a gap, is BBNJ, biologic resources beyond national jurisdiction. The United Nations has started a new conference round, which will or may end up in a new convention concerning the protection of the BBNJ, the biological resources beyond national jurisdiction. It sounds all very easy, although the mandate of this conference says no violation of the convention and protection of the environment or the resources, etc. You better look into the scenario. These are three different areas where these biological resources have to be taken care of. One scenario is the high seas above the deep seabed, and here recourse, or it will be necessary to fully respect the competences of the International Seabed Authority, which takes care of these resources on the seabed. The high seas above the outer continental shelf. Who is the one who will have to have this responsibility? And finally, the deep seabed, where the seabed authority is already active in this respect. That means you have 3 different regions to take care. Let me suggest, I see my time is soon up. Let me suggest a solution. Give up this conference. Just hand everything over to the International Seabed Authority. For these resources are common heritage of mankind anyway, and therefore the Seabed Authority is the appropriate forum to protect them. The authority will do so on the deep seabed anyway. I know this is not to the liking of diplomats, and particularly not those who are in favor of this new regime. I believe it has been triggered too much by biological diversity considerations, and rather did not take into account the environment, I mean the legal environment surrounding this convention, future convention. Let me, in 4 lines, come to a conclusion. The convention has been drafted as a flexible instrument. This flexibility should be used to adapt the convention to new challenges. BBNJ will not be the only one. In that respect, the convention resembles a constitution and should be treated as such. New instruments will only result in a legal chaos. Thank you very much.
And thank you very much, and now straight over to Professor Tuerk.
Yes, thank you. Well, let me follow up on this most interesting presentation by my colleague, Professor Wolfrum. And let me say at the outset, this 25th anniversary of the entry into force of the UN Convention on the Law of the Sea is really a most propitious moment to look at some aspects of its drafting and its operation in practice, as well as considering new challenges in the law of the sea. And to sum up, since it has entered into force, the Convention has played a major role in bringing order to the oceans and their marginal seas, in particular by laying down a clear and universal framework of coastal state maritime jurisdiction. Why has the Convention worked so well? Because it was adopted as a package deal and on the basis of a consensus procedure. Judge Wolfrum has already referred to the fact that not everything could be covered by the Convention because it is a framework treaty, and there are certain unavoidable gaps. In addition, there have been developments in the law of the sea that had not or could not have been foreseen at the time of the adoption of the Convention. This can either be due to the fact that the complexity of implementing some of its provisions had been underestimated, or because of scientific progress which has since been made. It has also to be admitted that some of the assumptions delegates were made to believe at the conference turned out to be wrong, but never mind. Let me also say that the highly complex and innovative dispute settlement of the Convention has been operating rather well and allowed to resolve or clarify some of the uncertainties in the law of the sea, be it by the ICJ, ITLOS, or arbitral tribunals. The Convention is a living instrument, and its application and interpretation will continue to be shaped by international jurisprudence as well as by state practice. And furthermore, additional international agreements, including further agreements implementing provisions of the Convention, will be necessary in order to cope with new challenges with respect to the law of the sea, in particular as regards enhanced protection of the environment, better conservation of maritime resources, and safeguarding of marine biodiversity. I had the privilege to participate for quite a number of years as a delegate of Austria at the Third United Nations Conference on the Law of the Sea. And let me address some of the issues dealt with at the conference in which I was personally involved as a negotiator. Austria was chairing the group of landlocked and geographically disadvantaged states. which in the beginning had some problems with the concept of the exclusive economic zone. And they tried to get participation rights to the living and non-living resources. Well, non-living resources were rejected outright by the coastal states concerned. As regards living resources, they got some limited rights, but which in practice turned out not to have any practical effect for landlocked countries, because at an age of continuing depletion of fish stocks, it would not have made sense to create new fishing fleets. Let me turn to the question of the continental shelf. The states with a broad margin had to accept an important political compromise in order to have their views accepted, that the shelf extends until the outer edge of the continental margin. That is the provision on revenue sharing in Article 82 UNCLOS. As you know, revenue sharing has a 5-year grace period, and the rate is annually rising from 1% to 7% after 12 years. With the benefit of hindsight, it may be said that the 5-year grace period is probably too short in order to recover the cost of the investment. And when this provision was drafted, wells were in much shallower water and closer to the shore than is the case today. As regards the percentage of contribution, proposals were made ranging between 5 and 15%. During informal negotiations, I suggested 7%, which turned out to be the figure that was in the end accepted. Once again, landlocked countries, at least they got the right of transit to and from the sea enshrined in the convention, which is an important success. Let me now turn to a particularly intractable issue dealt with at the conference, which was the regime of islands, which has been mentioned several times already. Because you had two views, either same treatment for islands as for any land territory, or certain qualifications in order to allow islands to have an exclusive economic zone and a continental shelf. This was in particular the view of the landlocked and geographically disadvantaged states. The current text of Article 121 only has this, as you know, the rocks provision. If rocks which cannot sustain human habitation or economic life of their own shall have no exclusive economic zone or continental shelf. The chairman of the second committee, Ambassador Aguilar of Venezuela, tried in vain to have more clarity inserted this provision, but it seems to me that some countries were quite content to have an ambiguous provision that suited their national interests. And as you well know, the arbitral tribunal in the South China Sea arbitration considered the status of the features in the South China Sea, concluded that these features are not entitled to an exclusive economic zone or continental shelf. Now, the problem is that the tribunal's findings are wide-ranging, expressing a restrictive position on the meaning of Article 121, paragraph 3, and which can be considered as setting a very high bar for small features to qualify for extended maritime zones. It has, however, also to be admitted that the interpretation of this provision by many coastal states, including rather important ones, as evidenced by their practice, seems to be rather the opposite of that of the tribunal, the United Kingdom being an exception which needs to be commended. So many small features have served as base points for proclaiming exclusive economic zones and claims to an extended continental shelf. I do not think it would be realistic to assume that states that have interpreted Article 121, paragraph 3 in what you might call a very liberal manner, suiting their own national interests, might feel encouraged by the arbitral award to give up any extended maritime areas around small and uninhabited islands. One may regret this, but I think that is the situation. And even if this restrictive interpretation by the arbitral tribunal were to be affirmed by another international court or tribunal, I very much ask myself whether this would change the position of the states to which I referred before. Now, turning to the work on the common heritage of mankind, the delegates at the conference were told that exploitation of mineral resources of the deep seabed would take place in about 20 years. Well, as we all know, this was completely wrong. It was also a mistake, in my view, that the convention was adopted by vote, which had the result that important industrialized countries refused to sign it. And despite the applause we just saw on this film before, which greeted the adoption of the convention, this might also be interpreted as a sign of relief that the difficult negotiations could finally be concluded after so many years. So I think this should be an important lesson for any future universal agreement relating to the law of the sea. Please try to stick to the consensus principle. And as far as the Convention of 1982 is concerned, the situation had to be remedied by the implementation agreement to Part 11, which is in fact not really an implementation agreement, but a protocol of amendment to the Convention, which brought the seabed mining regime closer in line with political and economic realities and now really made the Convention universal. Addressing the International Seabed Authority, I have to point out, in the beginning, this new organization was met with considerable skepticism. Now it is on a good track and really moving towards the exploitation phase, and exploitation regulations are supposed to be finalized already by next year, which would really be a major achievement. A question which had been underestimated at the time of the conference was the exact delineation of the outer limits of the continental shelf, so of the boundary between national sovereign rights and jurisdiction and the international seabed area. And the delegates of the conference had been told that it would be quite easy to define these limits. Well, the contrary has happened, and the work to be conducted by states parties in preparing submissions to the CLCS has been vastly underestimated in terms of its scientific and technical scope, as well as regards the considerable amount of financial expenditure and time. To prepare a submission takes between 3 and 10 years, or even more. And the CLCS has thus far received 84 submissions on the outer limits of the shelf, but has only been able to adopt 32 recommendations. So we will have to wait for decades until we know what really the dividing line is between national jurisdiction and the international seabed area. And this is certainly an unexpected and highly unsatisfactory situation which creates an uncertainty in the law of the sea, which the drafters of the convention had tried to avoid. Let me now turn to the last topic, that is marine genetic resources, which has been the subject of intense debates within the respective fora of the United Nations for a number of years. You are aware of the different views. Are they part of the common heritage of mankind, or do they fall under the freedom of the high seas? Marine scientific research. But despite these divergent views, I would like to emphasize that it is safe to say that the status quo of the exploitation of these resources is the freedom of the high seas, because the taking of samples of marine genetic resources in these areas, which has already been taking place for at least 25 years, has never led to protest or been questioned as being unlawful. The current ongoing intergovernmental conference in New York is also dealing with perhaps even more important topics, such as area-based management tools, including marine protected areas, and the obligation to conduct environmental impact assessments. I think the importance of marine genetic resources and their value for the future is being exaggerated. We were also told the deep seabed will render trillions of profits, but these profits have so far not occurred, and I'm very doubtful whether we really can expect, or the international community can expect, huge profits from marine genetic resources. To conclude, it is often being said that UNCLOS is suffering from certain deficiencies and gaps, and that the convention should be revised or amended in order to cope with new challenges facing the international community in the field of the law of the sea. But in my view, the only feasible way to further develop the universal law of the sea is to build upon provisions of the convention and also to operationalize general obligations already enshrined in the convention. And a good example for such a procedure is the 1995 Fish Stocks Agreement, which is a genuine implementation agreement, which is to be interpreted and applied in the context of and in a manner consistent with the convention. And it is also important to note that non-parties to UNCLOS can become parties to the Fish Stocks Agreement, and the dispute settlement provisions under Part 15 of the Convention apply mutatis mutandis. I can only hope that the negotiators at the present Intergovernmental Conference will, as far as possible, follow this precedent of the Fish Stocks Agreement. Let me emphasize that great care should be taken in any endeavor to supplement rules of the universal law of the sea, not to upset the balance of interests which lies at the foundation of UNCLOS, the balance of interests between different segments of the international community. And let us not forget, the United Nations Convention on the Law of the Sea was a major undertaking. It was adopted during a window of opportunity after many years of highly difficult and protracted negotiations. And I doubt whether an undertaking of such magnitude would be successful today. And I think this should be borne in mind. Thank you.
Thank you very much for another very rich presentation. And now, Michal.
Good afternoon, participants. Exactly 25 years ago, the United Nations Convention on the Law of the Sea officially went into force. Today, 167 states have become parties to the convention, which means almost universal recognition and application of its provisions in all parts of the world's oceans and the seas. I commend the organizers of this conference to allow us to highlight at this time the convention's impacts on the international rule of law in the oceans and the seas and draw necessary lessons from its implementation. I have the benefit of speaking after excellent speakers who have touched upon almost every aspect of the convention, and I wholeheartedly endorse those comments. So in the short time frame for me, I would like just to make some remarks on two aspects of the convention that have close connection with the situation in the South China Sea. The whole content of my presentation is already submitted to the organizers. My first remark would be the convention is a carefully crafted balance of interests and rights and duties of coastal states and the international community, which is vital for its universal acceptance and application. State parties who have expressed their consent to the provisions of the convention should respect its integrity by establishing their maritime entitlements and carrying out their rights and obligations in accordance with what have been clearly provided for in the convention. There could be matters that have not been regulated by the convention, and as stipulated in the convention's preamble, those matters will be governed by the rules and principles of general international law. And that means the definition of those matters and how those matters would be regulated should heavily depend on state practice and also the recognition of the interested states and the international community as a whole. And the second point I would like to make is regarding the legal framework for dispute settlement in Part 15 of the Convention. Many people have said that the legal framework for dispute settlement in Part 15 of the Convention is perhaps one of the most comprehensive and thorough framework in a multilateral treaty. And Part 15 endorses the principles of peaceful settlement of disputes, state consent in the choice of peaceful means, and the exhaustion of legal remedies. Part 15 also lays out in details the compulsory procedures entailing binding decisions to be applied in case the disputes cannot be settled by the use of the diplomatic process. And Part 15 also established some international court and tribunals for a special mandates for dispute settlement under the convention, such as the International Tribunal for the Law of the Sea, the arbitral tribunals established under Annex 7 or Annex 8, and the Seabed Chamber. So the resort to diplomatic process is, of course, always very important in dispute settlement and is always prioritized by states. But the obligation to resort to the judiciary process or conciliation with all the limitations and exceptions clearly set out in Section 2 and 3 of Part 15 is in no way a restraint of the principle of state consent. It is rather a commitment of the state parties to peacefully settling their disputes in good faith and respect for the international rule of law. In some disputes relating to maritime entitlement in the South China Sea, our Chinese colleagues are trying to argue that the matters like the historic rights in the maritime area enclosed in the 9-dash line or the maritime entitlements of the outlying archipelagos of a mainland coastal state have been not regulated by the UNCLOS and must be dealt outside the UNCLOS. These claims were already addressed by the arbitral tribunal in the South China Sea case between the Philippines and China. Ambassador Tuerk also mentioned in his paper that the tribunal set a high bar in the interpreting and applying Article 1213 to the Spratlys, and state practice in some other areas may not be in agreement with the tribunal ruling in this aspect. But I would want to register that until now, except China, who has rejected in total the tribunal's awards, no other state has officially made any doubt on the decisions of the tribunal as regard the invalidity of the historic right claim based on the 9-dash line or the use of the outlying archipelagos like the Spratlys to claim maritime entitlement, including the EZ and continental shelf of 200 nautical miles. So, we need to see that interested coastal states, including Vietnam, the Philippines, Indonesia, Malaysia, and other users of the sea, of the South China Sea, have never been in agreement with the Chinese claims. So in conclusion, I I would like to join my colleagues in this panel to emphasize that after 25 years of implementation, the UNCLOS proves to be a very important legal foundation for peace, order, and development in the oceans and the seas. I share the view that to further develop international law of the sea, we should respect the carefully crafted balance of interest in the UNCLOS and build upon its provisions to cope with new challenges. I thank you.
My thanks to all the speakers for being admirably close to all your time limits. Professor Beckman, would you like to now use some time for highlight some particular issues that you've heard from the panelists? Thank you.
Okay, thank you very much. I think there's general agreement that the UNCLOS, or the Law of the Sea Convention, was unique to the time and circumstances, that it's maintained its importance, it withstood the test of time, and that it could not be renegotiated in today's political environment. So we have to live with what we have. I agree with Judge Wolfrum that it's a constitution to a certain extent. It's been developed through the practice of tribunals, through decisions, both advisory opinions and contentious cases, especially the provisions on protection of the marine environment. This was absolutely necessary because the environmental consciousness of today, or even of the mid-90s, did not exist in 1982. And I think the courts and tribunals have played a very significant role in breathing life and environmental obligations into somewhat vague provisions in the convention. The other point from Judge Wolfrum that I'd like to highlight is what I consider a major weakness in the convention with respect to protecting the marine environment, and that is seabed activities under national jurisdiction, which means the mining of minerals or the mining of hydrocarbons. Article 208 calls for international rules and standards to protect the environment from oil and gas exploration, for example, but there simply are no rules and standards. The best practice of Vietnam is Petro-Vietnam's practice. The best practice of Indonesia is their national oil company's practice. The best practice of Bangladesh will perhaps be what their mining companies do. There's also, it's not just the rules and standards that are missing, partly because there's no international organization responsible for oil and gas. Who in the UN system would draft them? It would have to be the oil companies. You'd have to do it through an international conference rather than through a UN organization, because there's no lead agency at the UN responsible for oil and gas. The other gap is with respect to liability and compensation. If there is a major transboundary spill from an oil and gas offshore installation, there are no rules to provide for compensation. Ask the Indonesians about the Montero spill from Australia's economic zone into their waters. The next issue I'd like to highlight is, I guess, from Judge Tuerk. I sense that she doesn't quite agree with the reasoning of the tribunal on rocks and islands in 121.3. I sense also that he's suggesting in his text that states that have not pulled back their economic zone claims from small uninhabited features are not likely to change their conduct, even though the tribunal has given clear guidance. I would say that might be true with respect to Japan and Okinawa-Torishima, or the US with respect to some of their small islands in the Pacific. But I would ask this question: what if those same features were in another state's economic zone? I would think those states would pull back, or they would be going to dispute settlement, because the state in whose economic zone those features lie could ask for compulsory dispute settlement on the status entitlement of those features. I agree with most of what Ms. Ha said, one of my old friends from Vietnam, particularly on the importance of the dispute settlement system. I think we must not underestimate the fact that the convention was drafted as a package deal. Everyone had to accept the entire convention. They couldn't pick and choose which provisions they wanted. Part of the package was you can make no reservations. You cannot exclude any provisions. The other key part of the package was there is compulsory binding dispute settlement if there's any dispute on the interpretation or application of any of the provisions. This has been the source of several very important cases, including the South China Sea case. And in effect, when you ratify the convention, you are giving your consent to going to dispute settlement, to either arbitration or adjudication, with very, very limited exceptions. And if you believe those exceptions apply, you have the right to object, but it's the tribunal that decides whether your objection is valid. It's not the protesting state. I think some states' legal advisors still don't quite understand that, but I would be very wise of them to read the decision and perhaps could increase their understanding. I think the final point I'd make, I guess, with respect to Judge Wolfrum and the issues with respect to BB&J and all, my view on that, let's leave it to the BB&J negotiators. We're not there yet, and some of these issues, I think, will be resolved through negotiations. Thank you very much.
So I'm now going to abuse my position as the moderator to ask the panel some questions. We've heard, Michal, you picked up the point about the dispute settlement being a consent-based regime. We've heard comments that the convention is a living instrument. And Judge Wolfram, you referred certainly to environmental issues as being in progressive interpretation. Given these potentially competing factors, that states are consented into a dispute settlement mechanism, which they don't do lightly, and put themselves before the tribunal or arbitral tribunal to have their disputes settled. There's two issues that I'd like to bring out. One, firstly, the non-appearance of states in recent times, China, Russia. The second is a critique that in some of the awards or judgments, the court has adopted quite an overreaching or overstepping their jurisdiction to progressive areas. To what extent do you think either of these issues can be said to be a valid criticism of the dispute mechanism such that it might be undermined with regard to non-appearance or the approach of the court? Or do you think that things are still in a healthy state? So perhaps can I ask Judge Wolfram to start off, and if others have got comments, thank you.
I go to your second point first, for it's easier to answer. It is a tradition in international law as well as in national law that judgments are criticized. This is common. And I come from a country where we have a very, very powerful constitutional court, and it has just recently decided on an issue which is politically extremely controversial. The decision will please some, others it won't. But this is part of the dialogue or the discourse on legal matters which we have to accept. But I will now refer to a judgment, the first judgment actually, of the Constitutional Court of South Africa. It said that a certain regulation, which was very much pushed forward by Mandela, was null and void. Mandela appeared next day on TV saying, I dislike the judgment or the order, but I will do everything to have it properly implemented. This is a proper expression of the rule of law. We have the system that courts have the last words. We may not like it. Occasionally, on other cases, we like it, but we have to accept it as, and we are dealing with this issue here, as a matter to preserve peace. the stability of a legal order is one of the most important elements for the preservation of peace. We should never forget that. And therefore, we better accept judgments. They may come up positively or negatively. Coming back to the ITLOS, Japan was not very happy with the Bluefin Tuna case decision, but was later very happy with the Tomimaru and Hoshinmaru case. And therefore, once you win, once you don't. This is a matter which you have to accept. Let me come to the other point. The issue of not participating in proceedings is not a recent phenomenon. You all remember that the United States dropped out and did not continue to participate in the Nicaragua case after the court had decided it had jurisdiction. And we have other cases of that. This has been continued by Russia, as you indicated, and later by China, more or less at the same time, by the way. Now, in the case Ukraine versus Russia, Russia is participating fully. And this non-participating is doing harm, first of all, to the respondent who doesn't participate. Second, it is doing harm to the tribunal or the arbitral tribunal. For our international judicial system relies that we have two parties where the tribunal or the court is taking a decision. If there's one party missing, there's only one person to a dialogue or one institution. And this is one of the reasons why the South China Sea case took so long. For the court, the tribunal, had the feeling not every argument was brought up and not every argument had been properly looked at. And this was one of the reasons why there was an research done using the archives of the Royal Navy from the UK. And we also looked into other archives, France, Japan, and so on. Nobody had asked the arbitral tribunal to do so. We dealt with that for the simple and only reason that we wanted to have, in this case, the position of the respondent properly reflected. Therefore, the tribunal had to take part of the functions which had to be achieved by the respondent. I will not say whether the outcome might have been different, but one thing I'm pretty sure, that in the Arctic Sunrise case, I'm back to Russia versus the Netherlands, the non-participation was mostly harmful to Russia. There were arguments not being looked into, which may have turned the case. I was not involved in that case, therefore I'm speculating. Therefore, one should consider this issue. Judge Tuerk has rightly referred to, and so did Bob Beckman, the law of the Sea Convention is a package, and it included one very important element, that dispute settlement is mandatory. In this respect, the system is different from the one of the ICJ. By ratifying this convention, you are obliged to participate in a proper way with the dispute settlement system. You have a free choice whether you select ITLOS, ICJ, or arbitration. That is a liberty states still have, and there are the other possibilities under 297 and 298 to go to conciliation. They are effective, as we have seen in Timor-Leste versus Australia, and there could be other possibilities. Let me say, however, you may be astonished. I have been serving for many years as a judge, first as a national and later as an international judge, longer than as a professor, I believe. The best solution is always still the negotiated solution. I agree with that, but if there is no movement, then I believe the diplomatic means of dispute settlement like conciliation are very appropriate, and adjudication, be it arbitration, ITLOS, or ICJ, are the last resort. Thank you.
Yes, and if you could just also, on that address, mentioned Article 298 on exceptions and how the tribunal and arbitral tribunal should approach those in terms of narrow interpretations, broad interpretations in order to protect the consent-based regime. If you could comment on how cautious courts should be in finding jurisdiction where states argue that the exceptions are applied.
Well, first let me comment on just some observations by Judge Wolfrum. I entirely agree. Non-participation never does any good for the party which is not participating. And Arctic Sunrise is really a classical case in point, in which I also had the honor to participate. Judge Wolfram also mentioned a further topic, that is, if the International Seabed Authority adopts very strict regulations regarding exploitation of the deep seabed, what happens if a coastal state has a lower standard? And I've discussed this with the representative of an important developing country of the Asia-Pacific region, and we both agreed these regulations by the International Seabed Authority are adopted by consensus. So any state party to UNCLOS will also have to be part of a consensus on strict regulations. And it would be absurd and unacceptable if that state would, at the meeting of the ISA, agree to strict regulations and then adopt a lower standard in under its own jurisdiction. And we both agreed that there is a national discretion on the standard, but discretion only relates to adopting still stricter standards as has been agreed at the international level and not lower ones. You raised a further point?
Yes. So the additional point is the way courts should approach where states have entered into optional exceptions to the jurisdiction under Article 298, is how cautious should courts be to find that those are non-applicable when those are argued to apply, noting the consent-based regime?
Well, it's very difficult to make a general comment on this because each court, be it a permanent judicial institution or an arbitral tribunal, may have different views on this point. How far should we lean out of the window, so to speak, in defining our jurisdiction? So really, I don't think it's possible to give you a general answer.
Just one point. I think the tribunals in the South China Sea case interpretation of the exception on disputes on maritime boundaries was very well reasoned. The issue that's going to arise in a pending case is more difficult, and that's the dispute with respect to military activities. So the word military activities is mentioned only in one provision in the entire convention, and that's 298 on exceptions to jurisdiction. So this one, watch out for.
Thank you. Bringing up again a point I think Michal raised about arguing in regimes or legal concepts that are not expressly provided for in the convention, and the argument being that these are justified under customary international law that sits outside of the convention. And the argument often goes and relies on preamble paragraph 8 of the convention, which affirms that matters not regulated by this convention continue to be governed by the rules and principles of general international law. To what extent does the panel think that this really gives room for these arguments of new maritime zones, offshore archipelagos, these types of features, as opposed to bringing in the kind of principles like estoppel or other principles of international law? How broad a scope should this provision be applied?
Well, I'm cautious about principles of customary law because what is customary international law? There may be different views on what constitutes customary law or does not constitute such law. I think it's always wiser, if you have to interpret a convention, to rely on principles already enshrined in that instrument itself and try to develop these principles in a specific case, and not try to go outside the convention and seek help in customary international law. Because as a former legal advisor, I can tell you, customary law is often what the legal advisor of the foreign ministry thinks it is, and he may not always be right.
Yeah, this argument has been made by various scholars, including former FCO officers, with respect to mid-ocean archipelagos that don't meet the definition of an archipelagic state. I'll come back to, I believe this is not governed by customary international law. Go back to Article 5 of UNCLOS, says, unless provided by in this convention, the low water mark along the coast is how you measure your maritime zones. Also, when the archipelagic states provision in Article 4 was negotiated, it initially included India and other states that were trying to use straight baselines around their offshore islands like Nicobar Islands and so on. But it was dropped and it was decided they'd proceed only with archipelagic states. So now to go back and argue that's governed by customary international law, I think is pure fiction.
I think it is also important to define those matters that could be interpreted as being outside the framework of the convention, because as I noticed, many of those matters that have been argued that they are established outside the convention are in fact already regulated by the convention, like the two issues I raised. The tribunal in the arbitration case already show us clearly that these matters are governed by the stipulation of the convention. So I think it's very important that before we have to reach agreement, especially among the interested states, that this matter is already under the convention or not. And then if the matter is under the convention, then the interpretation and the application of the provisions of the convention must apply.
Yes, on your question, I agree with my colleague from Vietnam. Most of the issues are in fact already included in the convention or can be easily included into the convention. You have referred to the preamble. We could also refer to Article 100, whatsoever, 293, I believe it is, where international law can be incorporated, and this has been done by ITLOS. I mentioned already the environmental principles, sustainable development, precautionary principle. Don't forget the special chamber, Ghana versus Côte d'Ivoire, applied the principle of good neighborliness in the question on damage, transfrontier damage. Now, as to the archipelago, I believe what is an archipelago is very clearly limited to what has been stated in the convention. We have the land-water ratio, and you cannot include, let's say, an archipelago which has a huge land mass. This would not fit into the ratio land-water. This was well negotiated. Therefore, I believe there is no further possibility to add something to the convention. As to your other question before on exceptions, Article 297 and 298 are very difficult to understand. They are not masterpieces of drafting. 297 even less than 298. In the Chagos Archipelago arbitration, there has been given some interpretation of 297, and there is a reference to 298 in the South China Sea case, where it was given a different interpretation to military activities than it was by ITLOS done in the Ukraine-Russia dispute. Here we have a disagreement between the two bodies. we'll have to see how it works out. But also that happens. Remember the huge dispute we had once upon a time between the ICJ and the Yugoslav Tribunal, Nicaragua case, etc. This should not happen. It can happen. And ITLOS has, to a certain extent, established a procedure with the ICJ to not to come to these divergencies. We occasionally, or the ITLOS occasionally meets with judges of the ICJ, and this, perhaps it's not all that well known, but it's not a secret. This should be encouraged, that, for example, the question of the outer continental shelf, which was decided by ITLOS and arbitration, but is still pending before the ICJ. We'll see whether the ICJ follows Bangladesh versus India, Bangladesh versus Myanmar, and, well, let's wait and see. I believe ITLOS has good arguments to start that with.
Thank you. Just before I turn over to the floor, I think I'm right in saying that none of the panelists thought that renegotiating or opening up the convention for renegotiation was either sensible or even achievable. Everyone nodding at that. Yes, good. There are a couple of topics before the ILC at the moment. One is the sea level rise issues. The other is on piracy and armed robbery at sea and the issues surrounding that on their long-term program of work. So there are issues going forward, and those are two of many, where states may wish to codify the law more or progressively develop the law in some areas. Do you think then the right place for that, like BBNJ, is in separate additional treaties that implementing agreements, or those that are, in other words, supplementary to the convention is the way forward?
Take a step. First, a commercial. We're doing a workshop or a roundtable next week with the ILC subcommittee on sea level rise and law of the sea. So come to Singapore. It's a very difficult issue. I think it's an issue that the ILC should be looking at, because there's a risk of large-scale forced migration from states, the possible disappearance of states if they no longer has territory, and territory is a prerequisite to statehood traditionally. So these are difficult issues. With respect to piracy and the other maritime crimes, no, we have a whole series of supplementary conventions. So there's the Hostages Convention and SUA 88 and 245 Protocol and so on. And these are consistent with the provisions on arrest the ships on the high seas, and we certainly don't have to relook at UNCLOS. We've got some supplementary conventions.
On the sea level rise issue, we have decisions of courts on maritime boundary delimitation. Sea level rise, yes and no, cannot easily take away these judgments. We have international treaties in this respect, quite some. This can also be touched. Here again, if they come up with a solution, it will hardly fit into the convention. We have very clear rules, and the argument that the baselines are movable, and therefore the maritime boundaries is the opposite to preserving a certain stability. The issue which will definitely come up in a couple of years, perhaps next year already, is what to do with maritime areas where the islands don't exist anymore. I speak of islands, not rocks. This is a discussed issue. I've supervised a dissertation on that. It's one of the leading books on that. The author and I totally disagreed, but I will leave it to further developments. My sympathy goes very much with the inhabitants of these, like Vanuatu. But it's not a question only for islands, it's also a question for certain states. If the sea level rise is as expected, let's say 1 meter, then 1/3 of Bangladesh is in trouble. We face that. Therefore, we better fight the sea level rise, or allow these people or give them the funds to to take certain precautionary measures which are being taken by some other states. Therefore, who has been at the conference like Helmut and I? This conference was, after the Vienna Congress, the biggest, the least organized conference ever. I even tell this to Michal. We have hardly met each other ever. We were in smaller and smaller committees. I was in particular dealing with production policy. I'm a lawyer, but nevertheless. And I don't believe if we open this package, we'll never be able to put a package back together. For always there will be new developments, new ideas, new interests. We should, however, accept that the oceans, the protection of the ocean, is the interest of everybody, including landlocked countries, as Judge Tuerk has indicated, and those states are not very well heard very often. Therefore, leave it as it is. It is a good legal instrument with all its ingredients to further develop it, and we have the institutions to do so.
Well, let me just wholeheartedly endorse the observations by Judge Wolfrum on the convention. I just want to make a remark on piracy. I do not think we need any new instrument on piracy. We have the provisions in the convention, there is universal jurisdiction, and we have the convention on the suppression of unlawful acts against the safety of maritime navigation, which has been amended in 2005 and made much stronger, which also included the prohibition of the transport of weapons of mass destruction, using a ship as a weapon and so on in light of the terrorist attacks in New York. So I think we have the instruments. The problem is it's the will of the states concerned to actually prosecute pirates and put them in jail in the respective countries, because many states rather prefer to leave the pirates where they come from, send them back, and they often go without punishment. Thank you.
I also agree that it is not good to open up the convention and renegotiate it, but we need to build on the provisions of the convention, and the United Nations has already had the practice of negotiating and concluding implementing agreements, at least for 2 implementing agreements for the convention, and I think that is also one of the way that United Nations member states are following. Thank you.
There is an area where piracy and other provisions of the law of the sea will have to be examined, and that's the effect of autonomous vessels. Because piracy now is crew or passengers of a private ship against another ship. There's no crew. Can a pirate ship be a ship without a crew? Well, these are the complicated issues which we're beginning to take a look at.
That sounds like an article in waiting. So I think we've got a few minutes if, yes, I don't know if we can get a mic over there. Just take questions.
Okay. I have a question. As an international lawyer, I was so excited to meet so many judges here. And just talking about the rule of international law, I have a question. How can we deal with the fragmentation of the interpretation or application of the international law? Such as, for example, as we see that in the South China Sea case, when the tribunal deal with the military activity things, it says that in one circumstances, China doesn't say that it's a militarized activity, so it's not a military activity. And in the second Thomas Shaw, because it involved China's Navy there, China Navy there, so it's a military activity. But recently, in the case Ukraine versus the Russia Federation, the ITLOS says that the distinction between the 2 activities will primarily based on the objective evaluation of the nature of the activities while taking into account all relevant circumstances. And it can neither rely just on what the state is arguing about, nor just rely on the nature of the vessels. So it's a little bit, for the learners of the international law, it's a little bit ambiguous and vague, and sometimes get confused about it, interpretation. So my question is that how to deal with this kind of fragmentations of an interpretation. Thank you.
Okay, what we'll do is we'll take another couple of questions, and then, one here, and then I'll push them to the panel, so if you can all be preparing. So can we have a mic over here, please?
Thank you. I'm not a lawyer, but I'm also excited to see so many judges. This is the first time in my life when I face such a panel. Thank you. And your presentations were really very interesting. Let me ask a very naive question. I repeat, I'm not a lawyer. From the viewpoint of UN clause, how will you assess the future nature of the COC? What it will be or what it should be? An additional instrument, a supplement, or something else? What should it be if we just judge in the objective way of looking at the things? Thank you.
Okay, any other questions? Oh, am I missing an arm? Yes. Yeah, one here.
I wondered if I could ask you a question, Chair, if that's all right. As a Brit to a fellow Brit, I think the UK is the only state in the world that voluntarily renounced an EEZ claim from one of its features, feature in question being Rockall, a lonely outcrop in the North Atlantic. What would you say to other states who have unsupportable EEZ claims about the pros and cons of giving them up? Thank you. Oh, Admiral Koda turned around and looked at me from Japan.
I can't imagine why. So perhaps we'll take those questions in turn. Who'd like to take the fragmentation of international law question? Yeah, please, yeah.
You know, when ITLOS was created, in the very beginning, there was a lot of criticism, and distinguished international lawyers said, this new tribunal, its creation is a big mistake because it will lead to a fragmentation of international law. As Judge Wolfrum has already mentioned, well, there have been meetings between judges from the ICJ and judges from ITLOS to discuss certain issues, and one can really say that fragmentation of international law between these two bodies has so far not occurred. ITLOS has often referred to judgment by the ICJ, and the ICJ has also referred to an ITLOS judgment in its own judgment. But as we have a diverse system for the settlement of disputes, two permanent bodies and ad hoc arbitral tribunals, it is unavoidable that a certain body will have a different opinion than another body. But in the longer run, the more and more decisions are being taken by the various bodies, I think the more their views will be harmonized, because of course each body will carefully look at the reasoning adopted in the judgment by another court or tribunal. But you cannot totally exclude it. You also cannot do this in a national court system. You will have different views by lower courts, higher courts, and in the end, there is a Supreme Court to decide. On the international plane, we have no Supreme Court. At one time, there was the idea that the ICJ should be kind of a Supreme Court and other international courts should be subordinated to the ICJ, but thank God this did not materialize, this idea.
As to the question of different interpretations of the same term, when I was a very junior judge, I had to stay with a municipal court judge. We were two of us, and I said the applicant was right for this such and such reason. He asked us, and my colleague said that the respondent was right. When I had finished, the judge said, but that's okay, I believe you're right. Then my colleague spoke, just the opposite, and the judge said again, you're right. And then we both said, look, this is impossible. He said, you both are right. What I want to say is the following. Interpretation is not an abstract issue. The same term can have a different meaning in a different context. And therefore, what is a military activity, you have to do, and this I would like to answer also the first question, you use the proper ways and means of international law interpretation. You start with a word. What is military? And then you check whether the behavior of the state concerns has a military nature. Also, the military personnel can exercise police actions, and police actions can occasionally amount to military actions. You have to look into the matter. You have to look how the case was dealt. For example, in the Greater Sun, in the case between Russia and the Netherlands, at first, Russia did not treat the activity as being military. And this had an influence, significantly so. Therefore, wait and see. I cannot give you an answer, particularly due to the fact that I will be in the arbitral tribunal, Ukraine versus Russia, and we have to deal with that fact. As to the code of conduct, I believe states should make much more use of codes of conduct, even on the regional level. I referred to that when I spoke about the possibility to follow the port state control approach, where we have codes of conduct amongst various ports. There is an agreement between Hamburg, Hong Kong, and Singapore, and other major ports in the world which regulate how the monitoring and inspection should be undertaken. Codes of conduct are hard law, at least they are enforceable. Now finally to the question where Helmut Tuerk and I may disagree somewhat. After now the judgment is the award is in the world, there are two possibilities. First, states will or may, when it comes to a dispute, refer to this award on the delimitation. We'll see. We have many, many delimitation cases still to decide on. Apart from that, the Continental Shelf Commission, which has taken into account certain rocks and doing the delimitation of the seabed, may be become much more cautious. Sure, the United Kingdom is the only state I know of, frankly speaking, which has declared that a rock all is a rock and not an island. Remarkable, laudable, but it is the only one so far as I know. But perhaps we'll see what is going to come. Therefore, I'm rather optimistic. International law is being implemented in a process, not ad hoc mostly.
The military activities issue, I think there's a problem waiting to happen in the South China Sea, because not just of military questions of whether it's a military vessel or a use of naval activity or not, but because of the use of the gray zones and the maritime militia vessels, which may be under state control, but they're not marked as a warship as defined in the law of the Sea Convention. So the judges may get some very difficult cases to have to resolve. And we have a chair who I understand is a former Navy officer. Maybe he can answer this one.
That's the last remarks to you.
Regarding the question on the nature of the COC, I would like to comment that this depends a lot on the intention of the contracting parties. Right now, if the code of conduct in the South China Sea would be legally binding as called for by the ASEAN member states, then it would be a regional international treaty. But we don't have that yet. We are waiting for the outcome of the negotiations between the contracting parties. People have been talking about a possibility of a code of conduct, which is an updated version of the DOC. If that is the possibility, then it is not much more than a political document. And that is what I think most of the contracting parties are not looking for. Thank you.
And just, as I realise we're between you and a cup of tea or coffee, just answering the question on Rockall. Yes, I mean, it was quite a giving away very rich fishing grounds, but I think the decision at the time was carefully considered, but it was at the time, and I think would still be the case, that it would be to maintain that feature was an island would be totally unsustainable and not inconsistent with the convention. So if it was seen as a clear result of ratifying the convention. It is quite useful when we're in dialogues with other states to point to our own practice and encourage adherence to the convention by others. I can put it like that, but it does come up in dialogues, I'll put it that way. And in terms of militia, quite a complicated issue. I think the one on state responsibility, I think, is a really clear framework for addressing whether it's fishermen under instructions, effective control, or militia. The articles of state responsibility and how that comes into responsibility, I think, is a very useful framework to analyse those. Can I just invite you all to join me in thanking the incredible panellists that we've heard from today with incredibly rich discussion. Thank you.